afternoon, everybody. Students for the Promotion of International Law Mumbai, in association with Bali International Arbitration and Mediation Center and the Chartered Institute of Arbitrators Young Members Group India, is pleased to welcome you to a panel discussion on demystifying the long-term effects of COVID-19 on arbitration procedure and opportunities. SPIL Mumbai is a student-run committee based in Government Law College. We host a variety of events and competitions, including webinars, the judgment deliberation competition, panel discussions, legal article writing competitions, among many others. BIAMC is Indonesia's only international organization related to alternative dispute resolution and one of the premier providers of, of dispute resolution services in the Asia Pacific region. They are a non-profit service center located both in Bali and in Jakarta, devoted to international dispute settlement. The BIAMC Academy at www.biamcacademy.com offers various courses from essentials of arbitration to advice on international moot court competitions and drafting CVs. The Chartered Institute of Arbitrators Young Members Group India is an international center of excellence for the practice and profession of alternative dispute resolution. It is a not-for-profit UK-registered charity based across 149 countries, supported by an international network of 41 branches. CIArb provides education and training for arbitrators, mediators, and adjudicators. It also acts as a global hub for practitioners, policymakers, academics, and those in business, supporting the global promotion, facilitation, and development of all ADR methods. I would like to now introduce our esteemed panelists. First, we have with us Ms. Shreya Gupta. Ms. Gupta is a principal associate at Shardul Amarchand Mangaldas and a former managing associate of Bharucha and Partners, Mumbai. She has a master's in international dispute settlement, MIDS Geneva, and has worked for 8 years in the field of commercial litigation and international and domestic arbitration. Next, Mr. Rahul Donde. Mr. Donde is a counsel at Levy Kaufman Kohler, Geneva. He has acted as an arbitrator, counsel, secretary, and assistant of the Arbitral Tribunal in over 30 international arbitration proceedings under both ad hoc and institutional arbitration rules. Third on our panel is Mr. Harold Sippel. Mr. Sippel is BIAMC's academic director, among many other roles. He plays a key role in promoting international arbitration in Asia. BIAMC has started several unique and useful initiatives under his leadership. Finally, Mr. Dharam Jamani. Mr. Jamani, besides actively practicing at the Bombay High Court, he is also a member of the Chartered Institute of Arbitrators Young Members Group Mumbai and sits on the CIArb Global Steering Committee. Moreover, he is a counsel at the chambers of SU Kamdar. I would like to thank all our panelists for taking time out for us today evening and joining us for this discussion. I would also like to thank all the attendees for joining us today. We will be having a live Q&A at the end of the webinar, so please do send in your questions at that time. Would any of the panelists like to say anything before we begin?
Maybe just if I may, good afternoon and welcome everyone. Since I'm sort of representing the BMC here, I'm very excited to be here and to have so many in attendance. I do encourage all of you to send your questions via the chat function. This should be interactive. None of the panelists intend here to just speak about themselves and speak for themselves above all. We all intend to provide you with practical, actual tips you can ideally put into action right away. So do not hesitate, do not be shy. Thank you.
All right, thank you, Mr. Sippel. Is there anybody else, or should I begin?
I guess you're good to go.
Okay. So to begin, I would like to ask our first question of the day to Mr. Jamani. Mr. Jamani, do you think that the current use of modern technologies will make arbitration proceedings more efficient? And in this light, what effect do you think COVID-19 has had on the practice of international arbitration?
Alessandra, thank you first to SPIL for having me here. And thank you for BIAMC also for being part of this. I basically have worked with Rahul and Harold previously, and I've just met Shreya recently. It's the pleasure for me to be on the panel with the three of them. Um, getting to your question, I think without a doubt, the use of modern technologies has had a great effect on making arbitration proceedings more efficient. The main grouse, if I can say that, against the use of international arbitration as a means of dispute resolution in the last few years was the expense and the effort that went into international arbitration. And that kind of law, that's where international arbitration was perceived as having lost the advantage that it provided as an alternative means of dispute resolution to state court litigation. Now, for instance, given the stakes that are involved in international arbitration, you would ideally have a three-member tribunal. Most times, those three members are drawn from three different jurisdictions, parties and their respective counsel, again from different jurisdictions. At times, you have witnesses and experts coming from, those either the parties' jurisdictions or from other jurisdictions. And all of that would result in fancy and very exorbitant fees being charged by counsel, by experts, and add to that the heavy fees and the cost, not the fees, I must say the heavy cost to travel to the seat of the arbitration, the fancy accommodation for the arbitrators. It's only now that Bali has an international arbitration center, but previously Bali was considered as an exotic destination for having arbitrations. And the venue cost, etc. Now, the option to have video conferencing hearings has always been there, and so has the option to have electronic bundles for arguments. Have VC to have cross examination on VC, etc. But no one really opted for it. Physical hearings was the norm, which arbitrators, counsel, and parties preferred to stick to, despite the heavy cost that that came along with that. And this, I don't think, would have changed for several years to come. But the pandemic has, in a way, it forced the change virtually overnight. VC hearings have now become the norm in the last few months due to the inability to travel, the movement control orders, the lockdowns. And this, in my view, has made arbitration very efficient, both in terms of time as well as cost. There is no longer a need for counsel, for arbitrators, for parties to travel from different jurisdictions to the seat of the arbitration. We have now been seeing extensive cross examination spread over a matter of 4 to 5 days or even longer being conducted on VC. There are oral arguments being conducted on VC. Now, this all, though it was though the technology was available, no one would have really imagined that this would have actually been put into practice even as recently as in February 2020. Now, electronic bundles have become the norm. One more important effect we are seeing, therefore, is the increased focus on written advocacy and the reduced emphasis on oral arguments, because in a VC hearing, it is more to make it more effective and efficient. Parties are placing greater focus on written submissions. It's less and less your oral articulation skills that you normally see in a physical arbitration hearing or in a physical court hearing. So all in all, yes, the technologies that are available and which have been put into use thanks to the pandemic have definitely made arbitration quite efficient. I think there are obviously counter views that there are concerns that arise, such as for instance, how does the the tribunal, how do they pick up, any sort of the demeanor, how do they ascertain the demeanor of a witness under cross-examination? How do they actually ascertain body language, which, kind of helps to, for a cross-examiner? How do you ensure that a witness who's under cross-examination is not being tutored either by a person in the same physical room or remotely through the use of some technology? There are all these concerns, but I think that the efficiency that these technologies bring far outweigh all these concerns. And I think from the client perspective, it is very efficient, and it helps international arbitration to bring back the advantage that it had lost over the last few years. And so I think the biggest, to sum up really, the biggest advantage has been the shift from physical to virtual. And that is here to stay, I would feel. But given the the tendency that we lawyers tend to have to stick to our physical hearings, to stick to our physical briefs and bundles, perhaps the way forward could be a hybrid system where you have your virtual hearings, and then on a case-to-case basis you ascertain and you give the flexibility to have a physical hearing as well. That's really it from me on that one.
All right, thank you, Mr. Jamani. That was a great answer. My next question is for Mr. Sipil. With online arbitral hearings becoming the norm, many people have questioned the security of these hearings, and parties are concerned about cybersecurity and how confidentiality should be maintained across all of those involved. So with this in mind, what must law students or professionals keep in mind regarding procedures to be complied with in order to safeguard the confidential information and interests of the parties involved?
Thank you, Alessandra. That's a great question, because among the concerns that Dharam raised just before, confidentiality plays a major role. There have been a lot of people who are concerned about this. Before I speak about that, 2 points very briefly. Thank you very much once again to all the other panelists and organizers, and especially everyone out there who's listening to this. It's great to be here. That's my first point. And if you allow me, just a couple of sentences also on the efficiency overall, and I'll be brief. What does efficiency mean? Efficiency means maximum output with minimum input. That's what efficiency means according to the dictionary definition. And it can be looked at from different perspectives. One perspective I realized, or experienced, I should say, recently was as counsel in a virtual hearing. And I don't think it was efficient at all from my own very personal and egoistic perspective, in the sense that I felt that as a lawyer, I could never be as good in a virtual hearing than I could be in a physical hearing. So in my view, the efficiency of the legal argument is decreased. The main reason for that, and I'll really not go into details, the main reason for that is that I simply am not in a position anymore, when I'm a counsel in a virtual hearing, to observe the arbitral tribunal, to really see how an argument that I'm making is perceived by 3 people. When there's 1 person, well, maybe that is still possible before a sole arbitrator. But before a tribunal composed of 3 arbitrators, it's impossible. You cannot observe 3 people at the same time, focus on what you have to say, and at the same time, possibly look at an exhibit that you're showing to everyone else, which is on the screen. So as much as I agree in principle that efficiency has been increased in many ways, I think we should always ask ourselves from what perspective we are looking at this. And well, it was made clear before, not everything is great, although there are, of course, many improvements. And the decrease in costs is certainly an excellent initiative or an excellent development. although I do fear that when we look at the costs of an arbitration overall, it is not that much how much we can decrease costs. Of course, it depends on the size of arbitration. Now, back to confidentiality. As I said, this is also one of the big concerns that people have in virtual hearings. There was a case in London, not in an arbitration, but in court hearings, where one lawyer sent out the link to a hearing that was explicitly, upon the orders by the judge, to be without the public. And this lawyer sent it out. It wasn't by mistake in this case, we would have to say. It was deliberate, but it didn't change the outcome that suddenly there were a lot more people who could see this hearing than there could have been, or there would have been ordinarily. And that's, of course, impossible in a physical hearing, because in a physical hearing, I mean, obviously no one else would come in, and if someone else who is not supposed to be there comes in, you just politely ask the person to leave the room, or you call hotel management or wherever you are, or security, and that person is being taken out. So that's something that would not happen. I think the recommendation, and Alessandra, you asked for what practitioners should have in mind. It's very simple. What there must be is a person, and ideally that's not someone from the tribunal, but someone else, who is in charge of admitting and also putting into conference / breakout rooms, etc., during breaks, the people involved in the hearing. And that person has to make sure that no one else can join. I don't think, and I'm not an IT guy, I'm a lawyer, but I don't think it's possible to hack yourself into a virtual hearing in the sense that you are there and no one else can see you. So the moment you have someone who really observes everything that's going on and who makes sure that only those who are allowed can be there, you are pretty much safe. Because we must not forget that as much as we believe that physical hearings are as much so safe, you could very easily sneak into a hearing room and place a recording device there underneath the table, just plug it onto the table, and you could record everything there as well. So it's not like just because this is virtual and because some people hack into other people's computers, that suddenly everything becomes so much more dangerous. So again, to sum it up, you have that one person or organization who is in charge. And in my view, that really solves the major concerns with confidentiality issues for a hearing, because the moment you have someone who observes who joins and who can select who is admitted and who is not, there is really no issue.
Thank you, Mr. Sipil. Ms. Gupta, thank you for joining us today. My first question to you has three parts. Firstly, how does the change in arbitral proceedings from in-person to a virtual proceeding affect the conduct and ethics of the proceedings? Second, is this a good or a bad development according to you? And lastly, which stakeholders do you feel are disadvantaged and which are advantaged?
Thank you. And I'd like to thank BIAMC and SPIL for this opportunity. And I'm extremely excited to be here with this panel today. To answer your question, I agree with what Dharam and Harold have said, in that the shift to virtual proceedings has certainly increased the efficiency, but there are other concerns as well. So as Dharam suggested, a hybrid system is probably what would work best. In terms of the current situation created by COVID, yes, it is the best possible alternative to avoid any delay or inordinate delay in proceedings, because we don't know how long this virus is here to stay for and how long the travel restrictions will be in place for. As far as the ethics are concerned, I read an article a little while back where it was said that international arbitration dwells in an ethical no man's land. And I honestly believe that virtual proceedings are very similar to that. They fall in the same domain. By and large, your ethical considerations remain the same, which is we must not tutor witnesses. Witnesses should not try to read documents from elsewhere. We shouldn't try to get people who are not entitled to be in a hearing into the hearing space, whether it's virtual or physical. And that remains the same. But what is slightly different and slightly more important is how we as lawyers deal with virtual hearings and whether we use the fact that there have been virtual hearings to have an award set aside by saying no, there has not been due process which has been followed. I had one case a few years ago where there was a virtual hearing. The arguments went on for about 8 hours. There was a voice recording, there was a transcript. Both parties agreed on the transcript, and after that, it was circulated to the tribunal. When the order came, the party that was unsuccessful raised an argument saying, we just realized that certain of our contentions were not captured in the transcript. And we think that the video may have dropped at that point, which is why you couldn't hear me. And you haven't considered those. And at that point in time, having the recording of the entire hearing was extremely helpful. And that is an ethical concern which arises in virtual proceedings, but I can't imagine that coming up in an actual hearing or a physical hearing. So I think that it is very similar, and it depends on how we deal with the situation at hand. As to who is the proceeding advantages for and disadvantages for, it really depends. For a claimant, it is certainly advantageous to have video proceedings because most respondents would try to delay by saying that they don't agree to having a virtual hearing, or that they would prefer, making their arguments in person. So it avoids that delay, which is why the claimant is at an advantage. But also the winning party is at a disadvantage because there are more grounds of challenge presently, which are available to the losing party, such as non-observance of due process. And with that, it eventually just rests in the hands of the courts who are faced with such challenges and how they decide or whether they give in to such arguments or not.
Thank you, Ms. Gupta. We actually have a question already from the question and answer chat. So I would like to ask Mr. Donde this question. The question is, how are we to handle a situation where one party is amenable to virtual proceedings and the other is reluctant, taking into account the principle of party autonomy?
Thank you very much for the question. I smiled when I read it, and the reason is that yesterday and the day before, I've spent about 4 hours each day teaching at Aberdeen University about arbitral procedure. And one of the scenarios I gave the students was precisely this one. So I have, the opportunity of having thought about this in some detail. But before I answer, let me join in by thanking all of our panelists for accepting to come and give their thoughts today. Thank you to the BIMC and SPIL. I'm particularly close to SPIL. Of course, I founded SPIL over a decade ago at GLC, and I'm very happy to see that it's only moved from strength to strength. That said, the question is a thorny one. It's not easy to answer, and when when I was studying to be a lawyer in GLC, a professor of mine then who still teaches then, and I shall not name him, said, Rahul, if you want to be a successful lawyer, there's just really 2 words you need to know. And if you know those 2 words, you'll be the most successful lawyer ever. And I said, oh, that's excellent. They said, what are those 2 words? Can you tell me? He said, yes, of course, I will tell you. And the 2 words are, it depends. And they can answer really any legal question that you're ever faced with anytime in your career. So I think here, the question really, the answer really is, it depends. If a request, or if there is a party that is reluctant to move to an online setting early in proceedings which are still in their kind of formative stages, still being processed, still initial rounds of submissions have just been filed, potential document production, then the tribunal will be, I think, a little hesitant to insist on moving everything that is to come virtually, and moving a hearing virtually, moving a hearing online as well. If, on the other hand, the proceedings have been going on for some time, there is the parties have already pled their respective cases, the evidence is somewhat complete, and the tribunal has a fairly good knowledge of the file on the basis of the submissions that have come in, then I think the tribunal can be a little more, and probably will be a little more insistent that the proceedings are moved to an online platform the best as they can be, to ensure that the arbitration is concluded in an expeditious fashion. And of course, the tribunal has to be very careful about both parties' due process rights. And you will see that, at least I've seen in practice, and Harold and Shreya may have other experiences, but you're seeing the tribunals are being increasingly creative in the ways that they try to get a non, what do I say, not, I wouldn't say obstructive, but a hesitant party to agree to an online hearing, for instance. So we have done a mock hearing where we replicate exactly the situation that's going to happen in a hearing. Everyone can test their microphones, etc., can have a look at the transcript, and the tribunal says, look, this works. We've also done hearings separated over many days, so all potential difficulties of time zones and availabilities, etc., are taken care of. So there are solutions. There is discretion available. The tribunal does have discretion in terms of matters of procedure, short of running afoul of a party's due process rights, but those rights must really be tangible and must be made out. I think the tribunal can take it upon itself to insist really strongly on having an online hearing, but that's just my thought.
Rahul, could I add something to that, if you don't mind? One point I'm sure you thought of, but you didn't highlight it as such, is, from my experience, it would also depend on what arbitral rules you are arbitrating under, because some rules may not even allow it when you look at the rules themselves. Personally, and I don't want to start this discussion because this would not be going anywhere, but personally, I take the view that the current ICC rules do not allow for the arbitral tribunal to force virtual hearings. But the virtual hearing that I spoke about just a moment ago happened despite the side that I was representing insisting that it's impossible. And one point, Rahul, you mentioned that arbitrators are getting more and more creative in sort of convincing parties to join those hearings. That I fully agree based on this experience. And you could see that even institutions got creative. And I'm speaking specifically of the ICC here. When you look at how the ICC justified that virtual hearings are possible, the argument was quite flawed. I mean, they, among others, relied on the French version of the ICC rules to explain the English version, although the English version is the original. Now, anyone who knows about contract interpretation knows that this makes no sense at all. So it's not just tribunals who get creative, it's even other stakeholders as well. But I do not criticize the ICC. I think from their perspective, and that's a very important one, one which must always be kept in mind. While procedural rights must be safeguarded, there is also the issue of, you finally have to hold a hearing. Under some arbitral rules, a hearing must be held if a party requests so. And if you cannot meet physically, then what's going to happen? And as Shreya pointed out before, we don't know at all for how long this is going to last. So if, I don't want to jinx it, but if we will be stuck in our countries for the next 2 years, then what does that mean? We cannot decide any disputes for 2 years. This cannot be it. So it's a very difficult situation.
I just wanted to add on to that, Harold, one thing. Correctly, you mentioned about the ICC rules and the internal inconsistency, which I just wanted to say that they've seemed to have recognized. So if you see the hearing provision of the 2021 ICC rules, you'll see that they've changed the language around quite significantly. And that ties into an answer that Dharam gave at the beginning as well. While you've had, the pandemic has produced an effect on arbitral procedure, immediately, I think there are some effects or some longer term effects that are going to be felt on international arbitration for the years to come. I mean, this virtual hearing insertion in quote unquote, because I don't want to take a position, that the ICC has done in its 2021 rules will obviously outlast the pandemic and will definitely be a modification to the arbitral procedure moving forward, which will, of course, compel, it has a top-down approach, right? It's going to compel a different kind of advocacy, which Dharam already mentioned. It's going to compel a different kind of education, a different kind of skill set that participants in international arbitration need to be aware of.
I fully agree. And if I may add just one more point, I realized myself 2 days ago that this whole process has had an effect on me as I'm acting as an arbitrator in proceedings right now. I'm about to, or I was calling for the preliminary conference. Now, as we know, that's a meeting that is mostly, unless it's a very big case, held via telephone hearing. But I asked the parties for the first time ever if they want to do it via video conference. And I fully admit it would have not occurred to me to do it via video conference before, even though some rules like the ICC rules already in the earlier version explicitly mention that this procedural hearing at the outset can be done via video conference. So I fully agree, Rahul, that there is this lasting change in many facets we wouldn't have imagined.
All right, thank you, Mr. Sipil and Mr. Donde. Mr. Jamani, you have plenty of experience in the international arbitration field in India. So our next question is to you. How can one excel in international arbitration when opportunities in their native country are limited? And what is your experience? What, in your experience, is the role of a barrister in the field of international arbitration, especially in India?
Thanks, Alessandra. Firstly, I would, tend to disagree that opportunities in the field of international arbitration in India are limited or, are limited anymore. If you see the stats, a great percentage of for instance, the CIAC's caseload in the last 2 decades has been India-related arbitration. In fact, I hold the view that Indian parties or Indian-related cases contributed a great extent to CIAC's exponential growth, in the first decade of this century. Similarly, if you look at the ICC's caseload, 2 or 3 in every 5 cases involve an Indian party or an India-related contract. But, the arbitrators that are appointed in these cases have been foreign. One asks, why is this so? it's obviously that if you have Indian parties, you have India-related contracts, why is it that they are arbitrating abroad in a foreign seat? Why is it that they are appointing foreign arbitrators? Why is it that they tend to go to foreign counsel? Actually, foreign counsel is because, you have a foreign seat and a foreign arbitral tribunal, and therefore, as a consequence, you tend to go with the foreign counsel. But why foreign seat? It's all attributable, to the over-interventionist attitude that our Supreme Court and the High Courts adopted qua arbitration proceedings, in the late 90s and the 2000s. Therefore, parties started taking their arbitrations to London, to Paris, Singapore, Hong Kong, which led to basically, foreign arbitral tribunals, foreign governing law, and engaging of foreign counsel. And that, I think, that situation was compounded in the by the appointment of only retired judges as arbitrators in arbitrations in India, and the very court-style manner in which those retired judges conducted arbitrations. Now, this, of course, as we all, I think all of us will agree, including Rahul, that and Shreya, that the arbitration landscape really started to change in India post-Balco, post the 2012 judgment in Balco, and then which was further helped along the way by the 2015 amendment to our Act. We are now seeing a lot more of Indian practitioners basically specializing in international arbitration, Indian practitioners being appointed as arbitrators in international arbitrations. And I believe that this number will exponentially increase in the years to come. We also have a lot of law firms who have a very specialized international arbitration practices. Shreya, I believe, has just joined one of those specialized practices at Shardul Amarchand. Similarly, other law firms like AZB, Cyril Amarchand, Luthra and Luthra, all of them now have specialized international arbitration practices. We have senior counsel like Mr. Parekh, like Mr. Sorry, I forget, the name skips me, or gentleman in Delhi, Rajiv Datta, who basically they specialize only in arbitration right now. So we are actually moving to see an arbitration bar being developed slowly in India. So I think opportunities were scarce, yes, in the field of international arbitration. You could say that was the case for till about maybe 8 to 10 years ago. But now I see a lot of opportunities that have opened up, and those will only increase. Now, moving on to what is the role of a barrister in international arbitration? As a counsel, is what we refer to a barrister in India. As a counsel, the role of any counsel or barrister is to evaluate, it's more to evaluate the client's case, advise and discuss the position to be taken, the formulation of the case, the regular drafting or the settling of pleadings, cross-examination, oral arguments. For this, of course, you need to bring a barrister or a counsel needs to bring much more to the table than than a practitioner, because you are really being engaged to add a lot more value, a lot more weight and refinement to the case. So for that, you have to be totally updated on the law, top of the facts of the case. There is no substitute for that. Many a times, you are asked to advise on the composition of the tribunal when, you are you're trying to set up the tribunal. For instance, that is because if you have a good case on law and a weak case on facts, you would want a judge who's a stickler for the law. If the situation is converse, you want a judge who is liberal and more fact-oriented. We have some very good examples of that. Many of you who are studying in GLC in Bombay would have and may have been interning, with lawyers in the High Court, would have seen perfect examples of judges who are, who fit these parameters. You also have to have an up-to-date understanding of, how the arbitrators, how their prejudices, their approach to the law, to the cases. You need to know how to pitch your case basically before a particular arbitrator. This is very important, because the manner in which you articulate and pitch your case can really be the difference between winning a bad case and losing a good case. So all in all, a counsel or a barrister really brings his legal acumen, his articulation skills, and court craft, as we call it, to the table. And this, of course, takes years to hone. It's not something that you can just start counsel practice or start practicing as a barrister and build this up. It takes a lot of hard work, a lot of basically being beaten down and being scolded and abused by the judges in the courts and by the arbitrators, pulling you up and getting really harsh with you. It's like you keep getting knocked down and you have to keep rising up again, and then basically learning how to rise from that setback. And so it is really that. I'm not, it seems that it's not too much, but it's a very different and a very super specialized role as a barrister or as a counsel in international arbitration or in any court litigation, because you need to really bring your added or your super specialized knowledge and experience to the table. And we are now actually seeing a lot of barristers and counsel who are specializing only in arbitration, and they don't appear in the courts at all. So I guess all in all, we should have an arbitration bar in India very soon. And those will, I think, that is only going to help increase the opportunities for the, law students and aspiring international arbitration practitioners. Thanks.
Thank you, Mr. Jamani. Ms. Gupta, I have a question that's a little bit more about you. How do you manage matters of personal concern such as stress and a work-life balance? And with respect to this, has the practice of arbitration had a positive effect on your life?
Thanks. I'll take the second part of the question first. The biggest benefit in the practice of arbitration is that it's planned well in advance. Your hearing dates are set in advance. Your deadlines for filings are set in advance. So you can plan your life with a little more ease than traditional court litigation. In court, you have no idea when your matter may get listed, and when it does, you have to be available. So if you have to plan a vacation or something else of personal importance, it's easier with arbitration, yes. However, whether you actually end up having a work-life balance or not is completely a personal choice. You will get as much work as you are willing to take on. And how to deal with it is up to each individual. So I find that it's very important to hold on to your hobbies right from the start, because once you lose track of them, it's very difficult to get back on track. And that's what happened to me. When I started work, I didn't do anything at all. And a few years in, I realized that I need something else in my day-to-day life to just, unwind or maintain my sanity sometimes even. So that is very important. The second thing that I think has helped me is starting my workday earlier, because in the morning, it's easier to focus. It's easier to get things done more, efficiently and quickly. And then you get done with your workday that much earlier. And somehow I find it much more satisfying to have that time to maybe go out for dinner as opposed to grabbing breakfast before work. So these are things that I think have helped me personally.
Thank you, Ms. Gupta. That's great advice from you. This next question is to both Mr. Donde and Mr. SPIL. It begins: the international arbitration world needs to be able to show that it can develop a consistent approach to the same questions playing out across thousands of arbitration agreements worldwide. Ensuring some sense of consistency and fairness over many cases is not easily accomplished, where hearings are held where hearings are held confidentially, and precedence is a guiding but not a controlling force. So, in this regard, a major question of interpreting the pandemic has surged under the force majeure clauses. Can there be a uniformly fair approach to this? We can start with Mr. Donde.
I was going to say we could start with Harold because he's the expert
Whatever
on the
you
issue.
prefer.
No. I'm happy to. I'm happy to go. I'm happy to go first. Of course, there's no problem with that.
Please
In
do.
terms of the simple question as to whether it's possible to have a uniform approach towards the application and interpretation of the defense really of force majeure, I think the answer is no, and it should be no. It's a very particular fact-specific defense that must be established, I think, in exceptional circumstances and very much dependent on the facts in the case. Whether or not performance was, depending on whatever threshold you apply, impossible or extremely difficult or extremely onerous, burdensome, what have you, must really be established in the context of that particular case. In terms of whether you would consider and classify the COVID-19 pandemic generally as a force majeure event, I think that also depends a lot on the particular context and the particular country that you're in and where the performance actually had to take place. It could be, some countries are very well, are not that badly affected, and relying on the doctrine of force majeure, just citing the global effects of the pandemic, I think is wrong and should not be given currency to. What really needs to be analyzed is this fact-specific context, how a particular how that particular state and that particular region really has been affected by the pandemic, what the performance was expected, and what is now being sought to be excused. And I think you have good and bad arguments on both sides. You do have certain states that have taken some very broad, wide-ranging measures that have really nothing to do with the pandemic, and they've just used that as a convenient excuse and have said, oh no, we were compelled to take these measures because the situation on the ground is such that we were compelled to do so, and you can't really you can't really hold us liable for breaching any existing obligations because we've taken those measures because of the circumstances. That's one side. And the other side, you do have states that have taken very nuanced, very specific, sector-specific, industry-specific, region-specific measures as well. And I think in those instances, you need to be more careful as a tribunal. You need to be more careful and see, whether those measures really do meet the requirements of force majeure as they appear in your contract and in national law. The other reason why I think it's hard, and I'll end with this, is to have any kind of consistency in the application of the doctrine really of force majeure, is because very often you have idiosyncratic force majeure definitions in contracts. And so you have the domestic law which says X and imposes 5 requirements on force majeure in order to claim force majeure, and then you have the contract that only recognizes 1 or 2 of those requirements. And then the tribunal, subject to, again, surrounding circumstances, may say that the parties agreed to narrow down the law given 5 requirements to 2, and we're only going to look at the 2. In that case, then applying that decision of that tribunal to another tribunal that's applying the law as opposed to the contract would be wrong. But that's all I would say. Thank you.
I was once speaking at an online conference, and there was an Indian lawyer who practices law in Geneva, and he gave me this advice that if I want to be a really successful lawyer, I should say it depends. And this is what I'm doing now. It depends, Rahul, from which perspective we look at it. I agree with everything you say. Can there be a uniform approach? You could say, yes, there can, if we say we make the model law on force majeure, if you want to say so. Take the unit draw principles, of course. But you looked at it from a completely different point, from the actual point, and not just from a theoretical point, which I fully agree with. That's the right approach. I think what we must keep in mind here, and this is really just explaining the practical importance of what Rahul, you mentioned. The practical importance and implication is that you have take an Indian company which has a contract once with a party from, say, China, and the other time with a party from, say, Austria, where I'm from. And let's assume that it's a standard contract this Indian company uses all the time, and the language and everything in the contract is the same, but except for the application, once it's Chinese law and once it's Austrian law. Now, because of this difference, the outcome may be completely different for that Indian company. And I'm really just making up the countries here. It can be any country. And this is what is the situation we should avoid, because this creates so-called transaction costs, the costs for companies to enter into contracts with companies from other countries, because there is this legal uncertainty. This is something we should avoid, and it's a cost which we should ideally minimize, because ultimately this is what makes everything more expensive and what is simply inefficient. The only ones who benefit from that are us, the lawyers. But ultimately, we want our clients to strive. So if our clients have fewer problems, you know, we would ultimately be happy, because we could possibly even increase our hourly rates. No, I'm just joking. But the point here is this really has a lot of practical implications. Everything that Rahul said from the legal perspective, which I fully agree with 100%, has all those practical implications. And what a lot of people forget is that force majeure does not only play a role now, since we have COVID-19, it plays a role all the time, because there are constantly disruptions that happen all around the world. You have one factory in one country which is burning because there is an accident, and suddenly the supply of product XY all around the world drops by 25%. This is not an example I'm making up. This has happened numerous times. And Germany, again, is just a random country I'm picking here. So force majeure is something that happens, unfortunately, on a daily basis. And this is why I believe ideally there were a uniform approach, but as Rahul has pointed out, there is not. Thank you.
Thank you, Mr. Donde and Mr. Sipil, for your answers. Ms. Gupta, you have worked at some of the biggest and best law firms in the country. So in your opinion and from your experience, do you think it's important to work at a big law firm in order to build a sustainable career in international arbitration? And what can you do to break into the field of arbitration when you neither work for a big law firm nor for a specialized boutique firm?
Right. Working at a big firm certainly has its advantages when it comes to breaking into the international arbitration space. And that is largely because the bigger firms tend to have a strong corporate client base, and then cross-selling allows you to pitch to those clients to take on their international arbitration work. So it's certainly easier, but it's not impossible to break into that space, even if you work at a mid-sized or a small firm which does not have that practice. I think the most important thing is to put yourself out there, and there are various ways of doing that. One is by attending as many conferences, seminars, etc., as you can, and networking with people. The second is writing articles and writing on blogs. Kluva Arbitration, for instance, is a great place to really put your thoughts out there. And there are a number of other such platforms which allow you to showcase your knowledge and your in-depth research on a number of international arbitration related topics. There are also various types of youth groups that are available. There's young MCI, there's young ICC, there's young LCIA, etc. And when you join these groups, it gives you an opportunity to interact with other people who are either in the international arbitration space or want to get into that space. And that networking, I believe, would help you to break into the international arbitration space eventually. It would take time. It requires a lot of hard work. And in general, you have to be willing to go out there and ask for work. Because if you don't ask for work, chances are you won't get it. So I think it comes down to that.
Thank you, Ms.
So if I can just add one thing to that before you move on to the next. I agree with everything that Shreya has said. I think that there are multiple opportunities out there for you to go out and try to establish yourself in the field of international arbitration. But I do think that with an increasing number of opportunities, there seems to be some sort of a decreasing quality. And I think that makes a big difference. So you have now, because there are not one blog, but there are 5 blogs, you have, people that are not doing as much research as they would do ordinarily, because they know that it'll get published somewhere. You have many people, you have many young organizations, so you'd rather be a member of 25 organizations rather than being a member of 5 and really making a positive value addition to those 5. So I mean, if I always tell people it's better to do a little and to do it well rather than to do a lot and to do it badly. So keep that in mind. And a really egregious example, I think, and I can give that I can give you is that there was a law student that applied to each and every member of my law firm, simultaneously asking them to act as a research assistant. I mean, this is like a classic example of something that you should not do. I don't know what the thinking was behind that, but it's something that you must actively avoid. That multiple opportunities available, many more than there were when we started, I'm sure. But that the quality must be maintained at all times.
Thank you, Mr. Donde. I'm going to actually come back to you with a question. Once a student has pursued an LLM abroad, what is your advice on building a career in international arbitration abroad? And what are the different career opportunities?
So first is what are the steps that one takes to make a career, and the second is what are the opportunities, right? So the steps, I think personally, I mean, we can all speak from our own experiences. I pursued an LLM abroad. I did the master's program being offered by the MIDS, the MIDS master's program in Geneva, which Shreya graduated from a few years after I had. And I think that was a very important part of my international arbitration career building. One important step in building an international arbitration career. I think that a master's program does allow you the opportunity of liaising, interacting with a large number of different people from across the world, and you get to study in depth on a particular subject much more than you would in pursuing any other academy or any other course. So I think pursuing a master's program is important. Now, it has been quite some time since I did my master's. And there are, as you said, many more opportunities available now. So I think that is possible for you to get the same experience as others have moving abroad. I think it is possible now for you to have those experiences more locally, and you don't really need to move abroad, especially in this pandemic time. You could very well pursue a large number of courses from your home. There's no reason for you anymore to travel across boundaries. So for me, it does make a difference to pursue specialized studies in a particular in international arbitration. I think that does make a difference. But I would also caution against, and this is from my own experience, I would caution against jumping into that immediately after completing your law school studies. I think having an element of work experience is extremely important. International arbitration is a procedural framework. When you pursue a master's, it's a procedural master's. It's not teaching you anything about substantive law. It's not teaching you anything about actual practice of law, which is quite different from what you study in school. So I would caution against immediately jumping into an arbitration-oriented master's immediately after graduating without first having had a few years of post-qualification work experience. Now, the second question, and I'm going to run through my answers quickly because I know that Harold is probably going to oppose what I say about the LLM. The other thing is, what are the opportunities available? I think there are so many opportunities available right now, and so many more than they were available earlier. But people just have to be a little thoughtful and a little creative when they're thinking of them. So the role of the arbitral secretary, for instance, is something which was not very widely prevalent or not so out in the open across the world 10 years ago as it is now. And that is a very, very valuable tool. It's a very valuable skill set. It really gives you a very good insight into how exactly arbitral tribunals work, what exactly counsel should do, what they shouldn't do, what are the kind of experts that you should present, what are the kind of witnesses that you should avoid. It gives you an insight, I think, an almost unparalleled insight into an arbitration. And that's a role that wasn't there earlier. You also have now roles being played that, for instance, arbitral institutions. There are so many arbitral institutions. BIMC is a good example, but there are others in Asia as well that are providing very good exposure to international arbitration. Even interning at those institutions makes a big difference. It exposes you to the world of international arbitration, to the conduct of an arbitration from an institution's perspective. And you get again a different kind of insight into the international arbitration beast. Dharam, for instance, is a barrister that's working in international arbitration. The skill set that you use, that you deploy in international arbitration proceedings, is somewhat different, and I think he'll agree, is somewhat different from the ones that you would adopt in common court craft. So you have barristers that are being able to kind of switch between these two roles, and I think that's an avenue that a student should consider as well. Taking up a barrister role, joining the arbitration bar, as Dhara mentioned earlier, and then you have the law firm approach, which is always present, right? You can join as in a large law firm or in a boutique firm. That's the more traditional kind of way of progressing in international arbitration. But I did want to flag that there are many other possibilities as well, and you need to be aware of them. You need to read about them and potentially try them out, and then take a decision if you're interested in doing that or not.
If I can just add one thing, I agree with everything that Rahul has said. What happens, and I also agree that it makes most sense to work for a few years before you go for a specialized master's, because it helps in more ways than one. One is you take that practical experience that you've got, and you can actually then apply the theory that you learn to the practical side of things. But having said that, once you work and then go for a master's, a lot of people find it difficult to start afresh as such in a foreign country after doing a master's abroad. And I know, because that was the thought that went through my mind when I went to the MIDS. You have to start, it's a completely different legal system at the end of the day, and you have to start at an intern level, maybe do a training contract, and then work your way up. What I would like to add is that in the larger scheme of things, it does not make a difference whether you take 2 years longer to get to where you may be if you stay in your own country, or maybe even 5 years. In the grand scheme, it does not make a difference. So that should not act as a deterrent.
I think I also need to say something, since Rahul has invited me to share my "it depends." First, one thing on the opportunities. Rahul has very well explained about those, and I think he made it clear, but I want to emphasize one point he made is, don't just go for the big shiny thing, the best law firms, so to say. I mean, that's great. Do apply to them, but you may get a much better experience somewhere else, in a boutique firm, for instance. In principle, that's my own experience. The smaller the organization, the bigger role you will play. And it's great if you can say that you worked on, an arbitration, the amount of dispute of which was $30 billion US. but everyone knows that you will have only dealt with the exhibits. Everyone knows that you will not have drafted anything in this arbitrations if the amount in dispute is so big. And the question is, does it really give you that much of a great experience? Or should you, like Rahul has suggested, pursue or consider pursuing a role as a tribunal secretary, where you may even be lucky enough to get personal insights from the arbitrator, because that arbitrator is not just your boss, but she or he also mentors you, because you work very closely together with that person. Now, arguably, when you take that letter role, you will learn much more than you would if you are the 30th person on that one big case. But of course, that one big case is much fancier, much sexier, if you want to say so. On the LLM, yes, I have a different view. And that's not because I never took an LLM. I took an MBA, which at the end of the day is the same mistake, I believe. And I don't think I made a mistake. I'm joking here. But what I think a lot of people underestimate, and that's really something I keep preaching to everyone I speak about, is you have to think of the opportunity cost. Now, what is that opportunity cost? It basically means, what is your next best alternative? Do you need an LLM to get into international arbitration? Well, clearly not, because else I wouldn't be speaking here. That's one. Two, what are the opportunity costs? You lose 1 year of income, 1 year where you could earn very good money. And you also lose 1 year of practical experience, because when you do your LLM, you don't get practical experience. And in my opinion, you can get the theoretical knowledge you get from an LLM while you work, when you do it on the side. I did it. I took a postgraduate diploma in arbitration. And the 2 courses I took in arbitration are the same courses that those doing an LLM would have to take. So there is little difference. So it's absolutely possible to get that theoretical knowledge. Something you cannot get, and I'm very glad that Rahul mentioned it, is the network. It's living abroad, experiencing a new culture and all that. But the question is it worth it? And in my opinion, the opportunity cost is very, very high. And yes, I fully agree with you, Shreya. When you look at the bigger scheme of things, 1 or 2 years of difference, it doesn't make that much of a difference if you look at a 40 or maybe even 50-year career, because these days, arbitrators just never retire anyway. So you can literally work until you fall off your chair and you're dead. But maybe I'm arrogant. You can condone me for that. But I would not have been ready to work for 3-4 years, then do an LLM, and then start on a trainee contract. I would not have been ready to do that. And again, call me arrogant for it. I would accept it, but I would not have accepted to say, I've come this far, I know my stuff, and now I got to start here. So this is why I'm somewhat critical about it, which of course only means that's my opinion, and you heard other opinions as well. It's up to you out there to decide what is best for you.
If I can just add to complete, the entire panel's views on this, I also did an LLM. So I am basically a proponent of doing an LLM. I wouldn't say that, you shouldn't consider doing it. You should. I actually I would, however, differ from what Rahul and Shreya said about, the timing of your LLM. There are in that sense 2 schools of thought. I don't say that one is necessarily right or wrong. It's actually a matter of perspective, and it depends upon personal preference. The school of thought that I believed and I followed was that, I want to complete my education at one go, do my LLM right after my LLB, and then start practice. Because I always felt that, once I get into practice, I was never going to be able to go back to studying, in academia, and then basically take a break in my career. Because in that sense, it does happen that, you would have spent maybe 3 or 4 years working your way up, and then you kind of take a break, and, it kind of, you need to restart again. So I didn't really subscribe to that school of thought. Again, I'm not saying that what Rahul and Shreya did is, wasn't correct or isn't the right way to go. It's worked for the both of them. And my approaches in that sense, I could say, worked for me. So there's no really right or wrong thing. It really boils down to what works for you and what is your preference. And honestly, the only thing I can add is an LLM really is more of a theoretical course. At least the LLMs that you do in the US or the UK. And the MITS LLM was not available at the time that I did mine. It came in maybe a few years later. So it's more of a theoretical course. It's not a very practice oriented or a very, practice oriented sort of course like an NDA, which teaches you the various nuances of doing business and gives you a more practical insight. So that again, really is more like, you are supplementing your education, and you should do a specialized LLM, because that in that sense helps you get that specialization. It helps you qualify for certain courses. For instance, if you did an LLM from Hong Kong University, you are entitled to become a fellow of the Chartered Institute automatically. If you did it from maybe a university in the UK or the US, you could be entitled to exemptions from the CIArb courses, some of the modules. So it's helpful for you from that perspective as well. And eventually, I think the most important part is going out there, building a network, and being able to then, whether you're able to harness that or not is really up to you. For instance, it worked for Rahul because, he shifted base from Bombay to Geneva immediately after his LLM. So, that's what he was, that's worked fantastic for him. There are others who have worked in Paris, who have worked in London, others who've chosen to come back and set up their own practices here. So really, it really boils down to what your personal preference is. All in all, yes, do an LLM, but do your research well as to where you want to do it from, what you want to specialize in. And as Harold rightly says, there is a very high opportunity cost. In fact, US LLMs are more expensive than the LLMs in the UK and Europe. So do your research well, maybe do it a couple of years later than you would. Don't rush into it. And once you decide to go for it, you should have evaluated everything from in a proper perspective, and then jump into it. And all in all, it does help. It will help you somewhere. I don't say that it doesn't. It's theoretical in a sense, but it does bring you a lot of opportunities, and it opened doors for me, and I'm sure it's opened doors for Rahul and Shreya as well, and Harold too. Thank you.
So, Mr. Jamani, I'm going to come back to you. Speaking on starting your career, law students entering their final years of college interested in pursuing a career in arbitration, and professionals looking to enter into the field of international arbitration for the first time in the career are facing difficulties in securing a job in the field due to the economic slowdown that has resulted in hiring freezes across the industry. So you said that you prefer specialization. So would you say that it is better to be a specialist than a generalist? And has this changed in times of this economic slowdown?
See, first on the economic slowdown and any sort of hiring freeze that may have happened, I think that will only have a temporary effect. It's not going to be long lasting. We have seen a very solid pickup in demand in various industries in India in the last couple of months. Factories and industries are working at over capacity. So they will, once demand has picked up, once cash flows improve, parties, especially in India, are very trigger happy to start in the litigation or arbitration. So that will again pick up. It's only a matter of a few weeks or months, I would say. Now, moving on to your next question so I would only say that students, just use your time well, attend webinars, do courses, and utilize your time well, and just wait for some time, and you will get those opportunities will come back. Those job opportunities are not going anywhere. Now, whether you should be a specialist or a generalist, I think for a student, you should not start off as you shouldn't start off saying that I want to specialize in a particular field, because you're still studying, you haven't really worked, you may have done some internships, and you may now have done some virtual internships, but you really haven't cut your teeth in the practice area. You have certain perceptions, certain ideas that oh wow, international arbitration is so glamorous, I get to travel the world, I get to stay in 7-star resorts, I get to hobnob with practitioners from across the world, and I basically will clock up my frequent flyer miles, get upgraded to platinum and gold, and all that kind of things. But that is all really a perception. International arbitration, as much as no one would want me to say this here, is a lot of hard work. It is a lot of hard work, and it isn't as glamorous as it seems. It can get quite dreary at times. It is quite monotonous. You wouldn't have like the courtroom drama that you see in maybe the Supreme Court and the High Courts, the courtroom drama that you see, the action, the suspense. There's none of it in international arbitration. It's very monotonous. It's very dreary at times. So I would say that you're rather better off starting off as a general dispute resolution practitioner. Start off with an open mind, dabble in litigation, domestic and international arbitration, maybe you want to do insolvency law practice. So dabble around, find your feet, see what interests you, what kind of keeps your fire burning, and then decide to specialize in whatever field that really gives you the, that really attracts you the most. For instance, I was initially very fascinated by the perceived glamour of international arbitration. I did an LLM with a specialization in international arbitration. My dissertation was on a topic related to that. But as I said, there's a lot of hard work. As Shreya rightly said, you get to plan your time, your schedule, but that doesn't take away from the fact that you still need to put in a lot of hard work, a lot of long hours, organizing bundles, going through all the facts, the law, putting together all those submissions, meeting all those deadlines. And as I said, arbitration rulings are not very dramatic. And that is something, personally for me, I really love the action and the drama of a courtroom. And that really keeps you and in court, you really need to think on your feet. Whereas in international arbitration, once you put in your pleadings, once you put in your pre-hearing submissions, you're not really going to have anything that's going to catch you by surprise. Everything's in there, and you're just really going through the process. Whereas in a court litigation, you have a lot of things. Sometimes, you have something thrown at you by the judge. Suddenly you have some thinking on your feet. You don't know how a particular judge is going to take a particular argument. So that really, that thinking on your feet, that really instant reaction when the judge is shouting you down, browbeating you, it really keeps you sharp and on top of your game. That does not necessarily happen in arbitration. So what I have felt is that though I still have a strong affinity for international arbitration practice, I still prefer to have it in a good 50-50 or a 60-40 ratio with court litigation. Because in that sense, it keeps you sharper and it keeps you going. If I was only to do international arbitration, I would think I would have burned out by now, perhaps. And so just, don't prejudge and preempt. Go out there, try your hand at everything, and then decide. And I really don't think the pandemic has had any major effect on this modus operandi that I just kind of mentioned. Your opportunities will come back. So start off as a generalist and then specialize along the way, is what I would say. Thanks.
Mr. Dole, could I quickly hear your opinion on the same question?
Sure. I don't think I have anything really different than Dharam. I think you need to be. It's a double-edged sword, but it's been a double-edged sword for the longest time. The double edge of the sword is the following: in order to show that you're serious about a field, you need to specialize in that field earlier and earlier on in your career, right? So if you're interested in international arbitration, then you're expected now, because there's a lot of competition in the field, for you to show that interest through blogs, through internships, through what have you, earlier and earlier into your law school career. And when you're doing that, you're kind of turning yourself away from doing other things. You're turning yourself away from taking an internship in a competition law team of another firm, because you're like, oh no, I have to do arbitration from like my third, fourth, and final year of law school. I must only do that because I need to show continuity. I need to show diligence. So it is a hard balance to make. I think that you need to be, as Dharam said, you need to be aware of the various kinds of it's the law. There is a huge number of areas that you can choose to specialize in. At some point, you do need to specialize, but don't try to do that too soon in your career, because then you may be pigeonholed into something, and then it's a little bit harder, not impossible, but a little bit harder to move across different subject areas. If at the same time, you can't be interested in everything. It's simply not possible. So if you can identify, just 2 or 3 areas and then try to pursue them with equal vigor, I think that would be the best approach. And then later on, 5-10 years after you've had real experience, after you've experienced it yourself, as opposed to having heard of other people's experiences of it, I think there's a big difference there. I think you can then decide whether you want to specialize in something or not. I mean, an international arbitration is not an episode of the Suits at all. It's very hard work that has to be done. And if you're of Dharam's personality and you like to interact with people and you like to go to court and you like to argue before a judge, then that may not be the best a place for you to go, because a lot of the time is spent in a small team in writing up briefs that are then put forth before a tribunal, and you have just one hearing over a span of a week or 10 days, and you'll have maybe 1 or 2 hearings a year at the most, and you simply can't do more, because there's even having 2 hearings a year is a lot. So it really, you have to give yourself the freedom to explore whether that's for you or not. And with that, I agree with Dharam. You can't wait for too long, though. I think the field is quite congested already, and it's also because I think it is part of the blame to be taken by all of us. We've given off the impression of international arbitration being like the sexiest thing to do, and that's why you have a large number of people that are taking it. And what is a little bit annoying, and I'm being honest here, is a sense of entitlement that sometimes creeps into people. Oh, I've done a master's program from the MIDS, or I've worked in 5 of the best law firms, and therefore you must be interested in me, and I am somehow entitled to this opportunity. And that is just not the case. I mean, I don't know if other people on the panel have different thoughts on this, but don't believe that the community of international arbitration really owes you anything, even if you're hyper specialized in it. So I would say moderate generalizing, and then at a later stage, whenever you're comfortable, and you are the own master of your own life and your own decision making, right? Whenever you're comfortable, you can choose to specialize.
So in the same breath, really, Ms. Gupta,
I think Harold wanted to say something.
All right.
No, thank you, Rahul. I just wanted to check, because I'm curious now. Could I ask, could us, the panelists, maybe just briefly state what route we took, whether it was the generalist route or the specialist route? I'd just be curious to see how we ended up, if you don't mind.
I'm happy to go first. I took the specialist route. I have only done dispute resolution. From my internships in law school to my post-qualification, again, I was working at a law firm in Bombay, then the MIDS, and then dispute resolution through and through. My wife, on the other hand, who's also a lawyer, is a pure generalist. She's done every possible internship in every possible law firm. So yeah, different views.
If I can go next, I have always basically wanted to be a dispute resolution practitioner. As I mentioned, I did my LLM in arbitration, and I've continued to be a dispute resolution practitioner all along. In that sense, as I said, I like to maintain a balance of basically a 50-50 balance between court litigation and arbitration, whether that's domestic or international. And sometimes, it does, depending on the caseload, it deviates between maybe 60-40 or 70-30 or the other way around. But that's where I would like to really maintain it, not super specialize only in arbitration, because I personally feel that, court litigation keeps you very sharp and it keeps that fire burning in you to keep practicing. Just a personal view, really.
I've always done dispute resolution only from my internship days to when I started work. In the beginning, though, between arbitration and litigation, there's always been some amount of balancing to be done. Typically, I've always done about 70 to 80% arbitration and 20 to 30% of litigation. And I think that's a good balance to have, because while the substantive law remains the same, I think it's important to know both procedures. Because even in arbitration, more often than not, eventually, whether it's at the challenge stage or the enforcement stage or execution stage, you have to come back to court. And you will be lost if you don't know those procedures at that point.
Okay. Thank you all. I was just curious. I also took the specialist route for sure. And I always find it interesting to ask this question, because my experience is that a lot of lawyers say that the generalist route is good. And I'm not saying I disagree. I don't know what is best. But very often when you look at those lawyers' career, it's the complete opposite. They are specialists through and through. So this is why I was just curious. But I'm not advocating anything at this point. I think ultimately it comes down to how hard you work and how good you are. And if you work hard and if you are good, then you will succeed either way.
Yeah, no, thank you for the question, Harold. It's very interesting that you ask it. It could be that all of us regret our decisions in the past. Or it could be that we're simply not, there's no practicing what we're preaching here. I think the idea, though, was at least the idea that I wanted to convey is that don't try to specialize too soon, too early on in your career. That's something that I think I did a little wrongly right from my first internship. Really, it's only ever been dispute resolution, and I would caution against doing that too soon on. You need to specialize. You definitely need to. You need to have an area of the law that you call your own, and whether it's procedural or substantive, it should be both, in my view. But my only caution is against doing it too soon.
And I think it's great that it comes from you, Rahul, even though that's what you did. Because that's much more telling than someone who did not do it and then says, "Look at me, I did it this way, and that's where I am." So it's telling, yeah.
So, Ms. Gupta, what would you advise young junior lawyers to expect their role to be in a firm that's practicing international arbitration?
To echo what Dharam and Rahul said, it's anything but glamorous. And fortunately or unfortunately, there is no substitute for hard work. So as a junior on a matter, it's important to get a sense or get a taste of every aspect. So it's important to be involved in research. It's very, very, very important to be on top of your documents, because if you don't know your documents, you will never, ever manage to stay afloat during a final hearing or during cross-examination. Preparing bundles, preparing first cuts of drafts, research notes, etc. These are all things which you would expect a junior lawyer on a matter to do. That is not to say it ends when you become a senior member on a matter. It stays. It's just as you grow, your responsibilities change and you take on more and more of it. That's essentially what changes. But there are long hours, very long hours, a lot of paperwork, and a lot of research that comes as part of it. It's a learning process.
I'm sorry I keep jumping in. Can I just really quickly add a point? I recently spoke to a mentee of mine from the Philippines who started out, and he was very frustrated. He said, there's too much administrative work. And I'm so grateful for what you said just now, Shreya. And I fully agree to what you said. It's so important to do the administrative stuff, so to say. You know, so many people are delusional. They think they go to a law firm and it's all about the law. There are no statistics out there, but a lot of cases are entirely decided on the facts, and the law really doesn't matter that much. Or it's just the question, was it this fact or that fact? And once you know, then the legal consequence is crystal clear. And you know, building on the it's not glamorous and it's not it's a lot of hard work. Please, by all means, don't get delusional about you know, thinking that a lawyer only works with the law. There's a lot more to just your legal books, so to say.
If I can actually just quickly add some sort of maybe a tip. I think when you're a junior lawyer or if you're an intern with a law firm, whether it's in whatever practice area, you should take as much responsibility as you possibly can, because that is something which goes a long way in you know, becoming a vital part of the team, and which will play a very crucial role in your growth. So take on as much responsibility as you can. Don't, in that sense, shirk responsibility, or don't just look at the watch. In your early days, you need to put in as many hours as you can and take on as much responsibility. Thanks.
A lot of advice. And my final point that I wanted to say is that Harold has actually been has created through the BIMC a page, and they put out videos where they have my #1 career advice for young lawyers. So yeah, if any of you are interested, it covers a lot of the points that we've covered already, and many other points as well, which are very critical. And I would encourage you to have a look at that.
So coming back to you, Mr. Jamani, there has been a shift in arbitral procedures from conducting in-person hearings to having them take place online over various platforms. And that has now allowed most lawyers to work from the comfort of their homes. This may definitely be seen as a boon to some, but however, provides a major obstacle to those hoping to enter or explore the field in terms of internships. In this case, what options do such students have? How do you think a law student or a professional could overcome this challenge? And what steps do you think could be taken by them to make the most out of the internship and the options available?
So just to understand your question, your big question is basically in the context of a virtual internship, is it?
Yes. Yes.
Okay. See, I of course, you know, it has had a major effect. I would say the pandemic and the lockdown, you know, and the consequent VC hearings have had this impact where lawyers are working from home, or as now the latest trend is working from anywhere. You know, we have now, you may have heard the Chief Justice of India commenting on Mr. Siddharth Luthra's background, that we can see the hills in the background, and it's good that you know, we see hearings, we can have a good, we have a good scenery to look at when you are arguing. So yes, of course, you know, on that lighter note apart, of course, you know, I think that this has affected the internships and the, you know, what a student could derive from an internship. I think my experience with virtual interns has been a bit patchy. Perhaps that is maybe because it took me some time to adjust to how to kind of assign work to the virtual interns who were with me since May or June of this year. But I think the work really has been confined to only basically legal research, preparing synopsis, and perhaps initially they had an opportunity to attend virtual hearings, but due to the bandwidth constraints that we have with the court, with the VC connections in the courts and even in arbitrations, that I think has kind of reduced the opportunity for virtual interns even to kind of be part of the virtual hearings. Now, I think, and more importantly, what I feel is, for an intern is for them to be for him or her to be part of discussions, discussions between clients, solicitors, counsel, for them to be physically present there, to be part of those discussions, to pick up the nuances of the case as to why a certain position is being taken, why a certain point of law is being articulated and being urged, and why some points which they would have felt are relevant are not being taken. They miss out on all of that. And I think that is something which is a major drawback of this VC hearings and these virtual internships. It also kind of becomes difficult due to time constraints and workload for us lawyers to actually, sit down with an intern over a Zoom call or something and actually explain to them that these are basically the outline or the outline of the argument that I propose to take. This is the reason. So those were some things which they would have themselves picked up in the course of client discussions or discussions between counsel and solicitor. So it's very difficult to even assign work to them very effectively. So I think that is something which, you have to really work upon and try to do as much. But I actually, as I said, I had a patchy experience with that. I wasn't really able to effectively harness the potential of the virtual interns, perhaps. And really, I believe that with physical hearings likely to resume soon, maybe in the next month or by January, this issue should be in the past soon. Till then, I would say keep making the most of the limited opportunities that you get on a virtual internship. Utilize your time to work on your hard and soft skills. Attend webinars like this. Notwithstanding, I of course acknowledge the webinar fatigue that all of us have, have basically been experiencing. You still should attend webinars. For students should, because this is a great mode of sitting in your home and attending webinars across the world for free and without the effort of traveling to those locations. And do short online courses, as Rahul mentioned. There are LLMs, there are specialist diplomas. The BIAMC is offering various courses. Sign up for those. The CIArb offers courses. So sign up for those. Try to build up your skills and your knowledge, and that's really what you could do possibly. Thanks.
So coming to Mr. Sipil, would you think it would be better to focus on theoretical learning during this time and possibly doing courses rather than virtual internships, which will help refine your knowledge and improve skills?
No, I don't think so, because I think you should do both. As simple as that, which of course is an easy answer because I don't have to pick between theoretical knowledge and practical knowledge, but I think you need both in order to succeed. My favorite arbitrations when I act as counsel are those when the opposing counsel is not specialized in arbitration, because that usually makes it very easy for me. The procedural rules are very complex. I just had a discussion with an arbitral institution this week about the English version of their rules, which is apparently different from the other version of the rules. I'm not saying any names because then you would know which institution it is. And apparently when you read the English version, you can make an argument that's totally different from when you read the other version. And both are originals. So if you are not specialized in procedure, at least, you would not be able to even make that argument because it wouldn't even occur to you. In line with that, unless you know what possible issues there could be, you cannot possibly find them. You know, if you don't know that in some countries an arbitration agreement cannot be assigned, you will not even raise any objection when the assignee files an arbitration, because you think that's normal. So the theoretical knowledge is super important. And of course, at the same time, you cannot say the theory is enough, because unless you have seen an arbitration yourself, you know, you will not know what it's like. And I remember many years ago, the outcry among the participants of junior lawyers when an Austrian professor of civil procedure said, and again, not mentioning any names here, but this law professor said, the main role of a chairperson is to forward all the submissions to the two co-arbitrators. This was clearly that person's view, which shows you that he had absolutely no idea what happens in an arbitration. And that's the downside of just doing theory. So you really need both, and you shouldn't focus on just one of those two. But you know, to maybe emphasize my point also that why you should do both. Think about it this way: if you were doing an in-person internship, it would very likely mean that you spend at least, I would say, 1 hour on going from your place and to work and coming back home. In some cases, that's possibly even a lot more. And also you can, if you're lazy, you can stay in your pajamas all day. You don't have to shave all day or, you know, whatever else you do. I'm not getting into hygiene here, but there is a lot of time you can save if you do a virtual internship. And if you are diligent, if you are disciplined, and all the time you would ordinarily use traveling from home to work and then traveling home, and you now use it to work on the theoretical knowledge, then you really can do both. And if you do a 1-month internship and you study arbitration for 1 hour every day, you will really improve your knowledge a lot. So this really is a time to do both. It's not just, you know, a pep talk. It's an actual, I don't know, value proposition, you could say.
So I'm gonna get to the questions from the participants, because I think we have exceeded our time already. A question that came in earlier is, how can international law and mediation help climate migrants?
That merits an entirely different webinar, I think. I don't know of an answer that I can give immediately in the time that we have available, but how can international law, like in general international law, help climate change and migrants? Yeah. I'm happy to have any of the other panelists take it, but I cannot think of an answer that I can give in a short period. I hope that international law does take it, and you have the climate change agreement now that the US will probably re-sign it. If I shouldn't say if I say if I become a Trumpist, when Biden takes formal reins of the US in terms of migrant policies, I think you have. You have international law being interpreted in any multiple of ways, and especially it's a big problem in the in Europe. I have no more general comments to make than that. I must say that I must leave right now. I do have another call that I need to get on that I'm already late for. It was a pleasure speaking with all of you, and please do carry on the conversation without me. Thank you very much to the BIMC and to SPIL as well. Thank you and bye-bye.
Thank you, Mr. Dhoni, for joining us.
Bye, thanks.
The only thing I could add to that question, I agree, it should be for a different panelist. The latest generation, or maybe not latest, but the later generations of investor state or I should say of bits of investment treaties, bilateral or multilateral, they often allow the states to also take action. So when there is an issue with respect to pollution, I mean, broadly speaking here, the issue of climate change, then the state can also take action. But yeah, it's a bit off the topic here, really.
So there was actually a question that, I'm sorry, Ms. Gupta.
Yeah, no, I agree. I think it doesn't really tie in with the international arbitration sphere, and it's more a general question for international law and how that provisions for migrants or migration due to climate change.
So there was actually a question from Mr. Sippel that came in. From your different perspectives as counsel and as an arbitrator, do you think that it is a common phenomenon that one of the parties objects to the proceeding with the arbitration remotely, or this is rather the exception?
You'd have to see the statistics. I honestly don't know. If I were counsel for the respondent, that's how the defendant is called in arbitration, and it would somehow be reasonable to make this argument, I would definitely make it, for sure, because it would allow me to, just cause some mess, prolong the proceedings. I don't know what Shreya and Dharam say, because although it was addressed to me, I think I'm certainly not the only one who can speak about his experience.
I actually had a very interesting situation where I was sitting as an arbitrator, and as Harold said, you would normally expect, and it would be quite reasonable in that sense for a respondent to make an argument that a virtual hearing ought not to be conducted for various reasons, and various reasons which they would in that sense set out. But in this arbitration, I was actually faced with a peculiar situation where the claimant was in fact not wanting to go to a virtual hearing, and I actually held two procedural meetings to try to understand the concerns that the claimant and the advocates had, the claimant's advocates had. And I was amazed with the kind of reasons that they gave me. They went to the extent of telling me that they were basically that the claimant's partners or directors were residents of a particular area where the COVID cases had suddenly started shooting up. There was road construction work going on, which increased their travel time to their lawyers' offices. And they went to an extent of also kind of trying to say that, because we're at a stage of cross-examination, how are we going to ensure that the respondent's witness is not being tutored, etc., etc. But it's very surprising. And I actually tried to, impress upon them that all your concerns are really not concerns, and your concern about, all these logistical ones that, it will take me longer to travel, I won't be able to effectively instruct my advocate, etc., etc., are really not concerns in that sense, and you should really move on with this because it is in your interest. But they've refused to budge, and finally I kind of gave up because I said, okay, as a claimant, you're in carriage of proceedings, and if you don't want to move forward, what am I to do about it? And in that sense, somewhere in the back of my mind, I made a mental note that for the period that the claimant has actually caused delay of the adjudication of the arbitration, I'm not actually going to award interest to them, because here's a situation where the respondent is willing to press ahead, and if you want to sit back and wait for your ingenuous reasons, you've got to suffer for it somewhere or the other.
Yeah, I think there are all sorts of excuses for not proceeding with virtual hearings that we hear of. One was where a respondent said that they objected to a virtual hearing because their offices were shut and they did not have soft copies of the entire record. And that, of course, did not fly because the claimant had everything in soft and offered to provide it to the respondent. But there has also been a case where it was an extremely technical construction dispute. And one part of the arguments, a large part of the arguments, was actually taking the tribunal through mock-ups that had been prepared for the purpose. And in that case, the claimant objected to a virtual hearing because they said there can be no substitute to those mock-ups and that presentation. But of course, the respondent was very happy to go ahead with a virtual hearing for the same reason, that there could be no substitute for this.
I think if I may add on this, there are situations, and I've been involved in several arbitrations where I, as the claimant, would have also wanted an in-person hearing. I'm thinking about the situation you mentioned now, Shreya. I several times I myself presented demonstrative exhibits in an arbitration, which were not just PowerPoint slides or printouts, but something. Once, believe it or not, it was wooden flooring, which sounds very odd, but that's what it was. And recently, that's just about 2 or 3 years ago, it was an arbitration in the fashion industry. And the manufacturer of those fashion products had several wrongly manufactured products which they presented, or which they were selling our clients. And we described them in our legal briefs, and we also put pictures. But when you actually presented those fashion products before the tribunal, you could really see the difference. And we thought before that our case was very strong, how we presented it on paper. But when we actually did it in person, it was completely different. And from the moment you could see the tribunal's faces when they saw those products, we knew we had won the case. And it was impossible to screw up that much to still lose the case, because it was just so obvious. So I do believe there are cases where even the claimant may have a strong interest. But at the same time, also, I find your approach, Dharam, to not award any interest, I think that's very, very reasonable, because you cannot, on the one hand, not move forward with the arbitration and then claim interest. That's just not right.
All right, so I think we have run out of time, and I'm sure all of you all have a lot of appointments to get to. So I would just like to extend my heartfelt thanks from SPIL Mumbai to all the panelists for joining us today. It was such a lovely discussion and a real privilege to speak with all of you. A special thanks to Mr. Donde, even though he isn't here, for getting us all together and helping organize this. Thank you to CIArb and BIMC, Rosa, and the BIMC team for being so helpful. And yeah, thank you. It was really enjoyable speaking with you all.
Thank you for having us. It was a pleasure.
Thank you.
Thank you. Bye-bye.
Thank you very much.
Bye,
it
everybody.
was a great moderation. No one has mentioned that so far, but thank you, Alessandro, for the excellent moderation.
Thank you.
Thank you, Alessandra. And bye, Harold and Shreya.
Bye, everybody.
Bye.
Bye-bye. Thank you.
Thanks all.